Hi, I'm Garth McNally and welcome to Garth's Hotties. Each month we're going to bring to you some of the hot questions asked in the superannuation space. Our first question has wider implication than just for the self-managed fund and will have implication for clients' estate planning. We recently picked up a new client who has an existing self-managed super fund. When we reviewed the fund, we noticed that only one member holds shares in the corporate trustee. Is this a breach of the SIS rules? Most of the rules around the structuring for self-managed funds are set out in Section 17A of the SIS Act. And the requirements we often refer to are that all members are directors or trustees, and again, all trustees and directors are members of the fund. It's interesting to note that there's actually nothing in Section 17A that covers shareholding. So there's no requirement in the definition of a self-managed fund that the directors of the corporate trustee and the members hold shares in that entity. However, to us, there are far more wider application and risks involved in regards to shareholding of the corporate trustee. Of course, those concerns and risks centre on estate planning. Now, I've got to set out now that it'd be very important at this point when you're talking to your clients to include their estate planning lawyer to ensure that the whole circumstances of the client's estate planning needs are considered, not only in setting the fund up, but also on the ongoing maintenance of the fund. The issue we see as being relevant is when it comes to shareholders, those that can have the right to appoint and remove the directors of the corporate trustee, that can have wide application in regards to paying out benefits on the death of a member. For instance, on the death of a shareholder, in most cases those shares would pass through to the estate of the deceased, and the person who inherits those shares could then, of course, make decisions about who the directors are of the corporate trustee. That director of the corporate trustee can then make decisions on how the funds run, and in some cases how death benefits are paid out from the fund. So in summary, the shareholding of the corporate trustee may not necessarily cause breaches under the Section 17A requirements of the SIS Act, but as we've set out before, can certainly be very relevant for clients' estate planning. I recently read an article that has me concerned. My clients are about to purchase a commercial office through their self-managed fund by utilising a limited recourse borrowing arrangement. The office being acquired is currently owned by the client personally. The building is worth $600,000 and the contents, including desks, chairs and cabinets and alike, are worth $60,000. The fund will borrow around 50% of the amount required. As the asset seems to be business real property, we believe that all seems okay. But can you please confirm this for us? You are right that self-managed funds can certainly borrow to acquire assets, so long as the requirements in the SIS Act, in particular Section 67A and 67B, are met. One of the main requirements of those rules are that the fund is acquiring a single acquirable asset. From what you've set out, the fund is in fact borrowing to acquire not only the commercial office premises, but also contents or furniture that exists inside the premises now. Based on that and our general understanding of the question, you may no longer have a single acquirable asset. You may now have one asset being the commercial office unit and a separate asset or assets being each of those pieces of furniture. If you were to use the one limited recourse borrowing arrangement for both the unit and the contents, the furniture, it'd be our view that you have a big issue in meeting the rules for a single acquirable asset. You may in fact need to have one borrowing arrangement, so one holding trust for the property and a separate holding trust or bare trust for each of those pieces of furniture, each being single acquirable assets. So it could get rather messy. You then need to overlay on top of that the issues that are covered in Section 66 of SIS, which talks about acquiring assets from related parties. In your question you set out the unit and hence the contents, we assume, are currently owned by the member personally. So the fund is actually acquiring an asset from a related party. In most cases, the commercial unit, the office suite itself, would probably meet the definition of business real property under Section 66, meaning the fund could probably acquire it so long as all those requirements under Section 66 are met. However, when it comes to the desks, the chairs, the furniture, in most cases that will not be business real property because it's not an eligible interest in land. It would not meet the business real property tests. So even though you might be able to fix up the borrowing issue around having multiple borrowing arrangements, the real issue is the fund should not acquire from the related party the furniture, the desks, the chairs. That would be a contravention of SIS Section 66. It would therefore be really important to review the contract that the fund is entering into with the conveyancing lawyer, of course, to ensure that you meet the single acquirable asset rules. So in other words, refer to the contract for fittings or fixtures attached to the contract, and making sure that they are in line with the single acquirable asset rules, together with the rules around acquiring assets from related parties.